The section that says that you cannot have an animal more than 2 feet away would obviously apply to dogs. And so owners who park their dogs outside of the store, I don't even know, that may be a crime in and of itself, but I do see it a lot around San Francisco, would be prosecutable under the statute because the animal is more than 2 feet away from the owner. Here is somebody who would possibly be prosecutable depending on how far the leash is away from his foot. It's the closest foot, so in this instance it would be his right foot. So if it was within 2 feet of his right foot, he would be in compliance. If it was more than 2 feet, he would violate the law. Because the ordinance would also prohibit objects from being 2 feet away from the owner, anyone who left a stroller in front of a store would also be prosecutable under the language of the statute. Now, of course, anyone looking at this would say a police officer would not, under any circumstances, arrest a parent who left a stroller in front of a store, for this. And they'd probably be right. I'm simply pointing out, under the language of the current version of the ordinance, this would be a prosecutable offense.
I actually think that's my stroller that's out there right now. Mr. Adachi, we're going to have to speed it up a little bit, please.
I did go out on Hate Street yesterday because I was interested in seeing what other kinds of activity would be prohibited. Here we have an individual who's playing guitar in the corner. He's sitting. That would be a violation. A person playing the flute, that would be a violation. This would not be a violation because this group of 5 musicians are standing up and performing. A person who is sitting down on the sidewalk, however, would be subject to a violation. The punishment for the proposed ordinance, and I state this because I think it's important for you just to know what the fiscal impact would be. For a first-time violator, you would face an infraction and a $50 to $100 fine. So under those circumstances, there is no right to a public defender or a jury trial because it's an infraction, so we wouldn't even come in on those cases. A second-time violator faces a misdemeanor prosecution and is subject to 10 days in jail. There is a right to a public defender and a jury trial if the person decides to exercise it. For the third-time violator, you face a misdemeanor prosecution and you're subject to 30 days in the county jail, and obviously you'd have a right to a public defender. This is hard to see, but I did bring copies for you. What this shows are all of the other crimes that are currently on the book. And they include solicitation, which is what you asked about earlier, Supervisor, relating to begging, illegal begging. That's Municipal Police Code 120.2. Obstructing the sidewalk, which is Municipal Police Code 22. I know there's been some testimony earlier about that. Penal Code Section 415, disturbing the peace. Penal Code Section 602.1, obstructing a business, and that is physically obstructing a business as the business is open to the public. Illegal parking, which is Park Code 3.12, obstructing the sidewalk, 647C, and that is a penal code violation. So there's actually 2 crimes as it relates to obstructing the sidewalk. 647C and 647F of the Penal Code, disorderly conduct. Also 332, which is not on this chart, which is public nuisance. That is being in a large group, creating noise, creating a continuing course of conduct that interrupts the enjoyment of the space to the community. 653.22 of the Penal Code, this is loitering with the intent to either buy or sell drugs. And then there's the Health and Safety Code 11550, which is being under the influence of drugs. And you can see that these are all misdemeanors, and these are all violations of law.
Mr. Adachi, I think we have a question from Supervisor Duffy, and then we're going to have to wrap it up, please.
Actually, my question's for the police department. Our public defender made some representations about 647C, and I wanted to have the department respond, so I'll let Mr. Adachi conclude, and then I'd like the department to comment.
Right. And I'm just at my last slide, so. The one thing I wanted to point out is there was some discussion earlier about Municipal Police Code 22 and why that would not be sufficient. In the right, let me point out why. It says, no person shall willfully and substantially obstruct the free passage of any person or persons on any street, sideway, passageway, or other public place. Now, for a first offense, this is an infraction. For a second offense, it's a misdemeanor and jail time. Third offense, misdemeanor and jail time. Now, this would appear to address situations where people were, in some way, obstructing the sidewalk. The reason why the police have a difficulty enforcing this is because there are two general orders. 5.03, passed in '94, which provides that police may not direct people to move along based on general complaints from residents, merchants, and others. The other is General Order 6.11, passed at the same year, which provides that police may not conclude people are blocking the street unless officers shall make reasonable efforts to identify, but at least must describe persons who are obstructed by the party to be arrested or cited. So these are additional requirements that are set forth in the general orders. Now, these are not elements of the crime. And the reason I raise this is because I know the process involved in passing an ordinance takes a lot of time and a lot of money. And if these general orders were eliminated, it would change the requirements that would have to precede an investigation, not necessarily an arrest for Municipal Code Section 22. The other thing that I wanted to point out is that this morning I checked my office's stats because I was very curious to see how many prosecutions we had for 647C, obstructing the sidewalk, and Municipal Police Code 22, obstructing the sidewalk, that we represented individuals in my office. And the answer for the last year, 2009, was 0. So we had no prosecutions for these offenses that actually went to court. Now, that doesn't mean that people were not arrested. People may have been arrested by the police, and those citations or those misdemeanors never made it to court. And but we have not had any prosecutions, so it would seem, at least, that Municipal Police Code has not been used in a way that would result in an arrest that would result in a court case.
Now, that doesn't sync up with other intimations that there are aggressive efforts in trying to abate this level of behavior, but not effective enough. And so you would think that if there were repeat offenders, eventually those repeat offenders that are causing some of the distress, the chronic concerns and frustrations, that they eventually would get to your office, right?
That's true, but I've talked to a couple of police officers who told me the difficulty in arresting somebody for the Municipal Police Code 22, obstructing a sidewalk, is that they have to have a witness. They have to have a physical person there that says that person is obstructing my way, and they have to have a specific complaint. They just can't have a general complaint from the residents. But these are not elements of the offense. These are, again, provided by the general orders I cited.
And so with the proposed law, no witness would have to be necessary, and if they do come to your shop without a witness present, then what?
You're saying if the Municipal Police Code was not, if the general orders were not amended? That's correct. I mean, this would be a basis to challenge it. But again, the only thing that a judge would look at or a jury would look at is the elements of the offense. And so here, the plain language of the ordinance provides that if a person willfully and substantially obstructs the free passage of any person or persons on a street, sidewalk, passageway, or public place, that's sufficient for a conviction, irrespective of how many witnesses you have, irrespective of where the complaint came from. These are just additional requirements that are imposed on police by the general orders cited.
Thank you. Supervisor Dufty to the police. Thank you, Public Defender.